Oh, thank you so much, and thanks everybody for being here today. So we are obviously going to be talking about this topic that is up on the screen, but I also, since I had a captive audience, wanted to take this opportunity to talk to you a little bit about something called ORCID. So if you have one of these handouts, it's like a half sheet. It looks like this. You may want to have that in front of you. ORCID is a unique identifier for researchers. So it helps to tie your research to you, and it's a free registration that you can go and get an ORCID number. And every time you publish, you can associate that number with your research. You can use it in faculty profiling systems. You can use it in Google Scholar Profile. You can use it all over the place. It really helps with name disambiguation if you have a common name. And it helps if your name has ever changed or you've published under different versions of your name. So this is something that the university in general is really encouraging all of our researchers to register for. And for some grant opportunities, it is now being required by the NIH and the CDC. And it is also being required by many publishers. So especially if you're in a STEM discipline and you do not yet have an ORCID ID, you may want to go ahead and register for one of those. All right, so that is the ORCID plug. And I'm going to, yes ma'am. Contact me if that's the case. I am the liaison from this campus to ORCID. We have an institutional membership with the organization. If you somehow mistakenly registered twice, we're gonna have to get ORCID people involved to fix that. So just send me an email and I will email my contact at ORCID and find out how to deal with that issue. But they're very helpful, and so we should be able to get that fixed if that happened to you. All right, so you have some other papers in front of you, and I'm just gonna briefly go over what they are. This one that has the title of the talk at the top, Deciphering Publication Contracts Books, is basically most of the information that's in the slides is here, and then there's a little bit more. So you may want to keep this one in particular. The other papers that you have in front of you are sample contracts. And I know that Allison sent these out yesterday along with a message from me letting you know that if you had a little bit of time just to glance through these, that would be great. But if you did not, that was also fine. So we're going to be talking about those at the end. But we have to start, before we can talk about contracts in publishing, we have to talk about copyright. Because a basic understanding of copyright in the United States is really necessary to understand any sort of publication contract. So again, my name is Jody Bailey. If you have any questions at any time during the presentation, please don't hesitate to just raise your hand, shout at me, whatever. I'm happy to answer them. My email address is here on the front of this slide. Also, this slide deck is available at this website, so it's bit.ly, so bit.ly/book contracts. It's a very simple URL that you can go to get a copy of the slide deck. My guess is, Allison, are you going to send this out to all the attendees? Yeah, okay, thank you. And the session is being recorded, but they're only going to record the portion of the session that's really like a presentation. When we get to the discussion part, the recording will stop. So you don't have to worry about having your comments or questions recorded. I'm starting with a disclaimer, as anyone does who talks about copyright law, and that is that I am not an attorney and this is not legal advice. We do not have an attorney-client relationship, especially since I am not an attorney. I am a librarian. I am pointing you to information resources. If you need legal advice, I strongly encourage you to consult an attorney. With that said, let's jump into our content today. So today we're going to be talking about what is copyright. We're also going to talk a little bit about open access because that is becoming more and more of a really salient issue within publishing. We're going to look at some contract structure and terms information, and then we're going to have a chat. So starting at the beginning here, the very basic information. And I want to acknowledge that my colleague Melanie Kowalski is here, back in the back on that side with the lovely polka dot sweater on. Melanie is our copyright and scholarly communications librarian. She is also an expert that you can turn to if you have any questions about copyright. And her contact information is actually on the back of this handout at the bottom. Okay, so you have contact information for both Melanie Kowalski and me. So Melanie, when she talks about copyright, she uses the metaphor of a pizza. And I kind of stole that from her. But I'm going to use the metaphor of a pie. So copyright is not one thing. It is a bundle of things. It's usually described as a bundle of rights. And you can give away some of those rights and keep some of those rights. It's not just all or nothing. So just as you can have a pie and you can give a piece of pie to your friends, to one friend and another friend and perhaps a third friend, you still might have some of the pie for yourself. So the parts of the pie are all of the things that are listed on the right. So this is what is covered in US copyright law as the bundle of rights that make up copyright. So when you have a copyright to something, it gives you the right to make copies of that thing, to distribute that thing, to prepare derivative works of that thing, to publicly perform or display that thing, and that really has a lot more to do with music and art and sculpture and things like that. But, you know, I guess you could figure out how to do an interpretive dance of your journal article. To license any of the above to third parties, and that's what we're going to be talking about today with copyright, and to transfer the copyright to a third party. So we'll be talking about those things in relation to open access and copyright. There's a link for more information, and that link, I believe I have it going to the copyright information page from the US government, which is actually a really good resource. So when is a copyright created? Many people are under the false impression that you must, when you create something and you want to have it copyrighted, you have to file paperwork with the US Copyright Office to have that copyright be official. And that is not the case. Copyright is created at any point that the thing is fixed in a tangible medium of expression. So for something that you're writing, that could be just taking notes on a piece of paper. If those notes are copyrightable, if they're sufficiently original to be copyrighted, then you have copyright right then and there. If you're making a poem and you're writing it down with your hand, you know, by hand in a notebook, that would be copyrighted. If you are typing on a computer, that would be copyrighted to you. So you own copyright in all kinds of things that you probably didn't realize you actually have a copyright in already. How long does copyright last? For individuals, and it's different for corporate authors when you have a corporation that's claiming copyright in something, but for individual authors or creators, copyright lasts for the life of the author plus 70 years. So that means that if you continue to own copyright in the thing that you create, it will outlive you. Okay, so your estate will inherit the copyright that you owned when you die. So this is going to become quite important as we chat later on. We're going to talk briefly. Yes?
So if I take a coin from a card, a Hallmark card,
Mm-hmm.
and then I send that to other people, send an email, a sympathy card of my own is email to someone else.
But you're using the words from the card that came from Hallmark?
Right. Is that then actually a copyright infringement?
Yes, as long as that card has been, yes. I mean, if it has sufficient originality to have been copyrightable, yes. So remember, there is in U.S. copyright law an exception called fair use that we use a lot in education. I'm not going to be talking about fair use today. That's how we are able to use a lot of copyrighted materials in the classroom and for other educational purposes without infringing on copyright, okay? So that's a whole nother ball of wax that we're gonna set aside. But if you have questions about fair use, I would definitely encourage you to talk to me or Melanie about those questions. But that's not really sort of the focus of today. So open access, we're gonna talk briefly about that. So before we talk about open access, I'm gonna talk about a couple of different models in which you can publish books today. And I've chosen some examples from folks that I know. The one on the left is from a friend of mine, Kenyon Zimmer, who was a former colleague and a friend at the university where I used to work. And he wrote this book that published in 2015 that was published by the University of Illinois Press. It is published under traditional copyright. If I wanted to have a copy of that book, and Kenyon wasn't willing to actually give me one if he had an extra one, I would have to pay $95 for a cloth bound, or there's cheaper versions like a paperback and an ebook, okay? The second model is an open access model. Debelina Roy, who works here at Emory, published this book also in 2015. And she was able to publish this book in open access. And what that means is that if I wanted a copy of this book, as long as I didn't have to have a print copy, the ebook is free. Not only is it freely available to me at no cost, I don't have to pay for it, it's also licensed in such a way that I could share it with other people, okay? If I wanted a print copy of the book, however, for those who really do prefer print, the print copy is available. You can order it and pay for it. So, what is open access? We talked about Debelina's book being published open access. What does that mean? It is the free, immediate, online availability, and in this particular definition it says research articles, but it can also apply to books and other things that are copyrightable, songs, for example, music, film, whatever, coupled with the rights to use these articles fully in the digital environment, okay? So those two things, free, immediate online availability of a digital thing, a digital object, with the rights to use them fully in the digital environment, make up open access. So how does open access differ from a traditional book publishing? So in a non-open access or traditional book publishing scenario, when you want to publish your book, you're going to be dealing with your publisher, and the publisher is going to require you to transfer the copyright of the book that you have written to them. They will then own the copyright, usually completely. They ask you to transfer all your rights. Remember how I talked about the bundle of rights at the beginning? They're going to ask you to transfer all of those rights to them in full, and then they will then own the copyright and put usually a full C with the circle in it, all rights reserved copyright on the book when they publish it. In open access publishing, the copyright remains with the author, okay? You don't have to transfer your copyright. So you still own your intellectual property. What you have to do, though, is you have to give permission to the publisher to distribute the copies on your behalf. Remember how I said part of copyright is the right to distribute copies of your work? So that's one small part of your copyright you do have to give to the publisher in order for them to distribute the work. So there are other differences, but those are the biggest ones. The way in which the work, the license that the work carries, so it's still copyrighted to you, but it's going to carry a license that allows for sharing. I'm just going to give you, these are the two books I talked about a moment ago. So Immigrants Against the State carries this copyright statement at the beginning of the book. You can see it's copyrighted 2015 by the Board of Trustees of the University of Illinois. So that's the University of Illinois Press. However, when we look at Debelina's book, we can see all these funny letters under where it says rights. There is no C with a circle in it. Well, there is a C with a circle in it, but it's copyrighted to Debelina. And then it has this rights statement. And the rights holder is listed as Develina Roy, not the University of Washington Press, who published the book. Why should we maybe think about OA or open access? I'm going to talk about this very quickly, but there are all kinds of reasons. When you get a copy of the slide deck, you can peruse these more fully, but very often, if you want to reuse your work in one way or another, you may have to ask permission of the publisher if you transfer your copyright to them, because you no longer own that work. They own that work, right? And to go back to your example, if you were to use, for example, say a graph or a chart that you created and then published, and then you gave the copyright of that thing away along with all the rest of the work, if you wanted to use that chart or graph in another work, you would have to go to your publisher and ask permission, unless there was something written in the contract that allowed you to do that. But if there was nothing in the contract allowing for that, then you would have to ask permission. It raises the visibility of your work. If you think about it, it makes sense. If something is freely available online, a lot more people are going to have access to it than if they have to pay for it, right? You may get higher citation counts. I don't know of a lot of studies that have been done with this with books, but there certainly have been more than 100 studies done for this on journal articles, and there is a definite citation advantage for open access journal articles. Some funders do mandate that you publish open access if your research, if the thing that you're writing reports on research that they funded. And then there are costs to libraries that are getting out of control, as well as the ideas around social justice and access to knowledge and information for people who might not otherwise be able to afford it. If you'll remember all the funny letters I showed you under where it said rights holder or rights and on Develina's work. So this is a very sort of common system that is used today for open access licensing. And these licenses are coming from a nonprofit organization called Creative Commons. This organization was founded by Lawrence Lessig about, do you remember 10, 15 years ago? Yeah, at least 10, I don't think more than 15, somewhere in there. And basically, Dr. Lessig, who is a law professor at Harvard, saw a real need for a new type of licensing, a new type of sharing. With the internet and our ability to share things, digital items so quickly, and people's willingness to share more openly, he really saw a need for people to be able to put permissions up front on the things they're creating so that people would know how they can be shared. Because before, all we had was copyright, all rights reserved on one end of the spectrum, and public domain on the other end of the spectrum. Public domain means there's no copyright whatsoever, right? These are sort of in between. It allows for a spectrum between copyright and public domain. So you can put one of these licenses on your work, and I'm not going to talk about them in great detail, but they go from most open to least open on this little chart. And one of the most common ones that's used is this one, which is CC BY, Creative Commons BY. That is the attribution license. That means I'm putting a permission on my work that I am going to share it with the world. Anyone else can use it, and all they have to do is give me permission. They can use my work verbatim. They can completely copy it. That's totally fine with me. If you'll notice, I have that license on my slide deck right here. So that's what that license says. I own copyright in this work, but any of you could take it and use it exactly like this, and all I'm asking of you is that you attribute me as the creator of this thing, okay? Other licenses might require that the person using the work share alike. SA is share alike. That means I'm requiring you to put the same license on your creation that you're basing on mine as I have on my license. There are other ones like no derivatives. So in other words, if you were to use this and I had an ND part on there, it would be, you couldn't make any changes to my thing, okay? A lot of photographers like to use that one because they don't want their image being cropped or having colors put on it or something weird like that in Photoshop. And the other one is NC, which is non-commercial. So you can use my thing, whatever my thing is, but you can't make money off of it. You have to use it in sort of a non-profit way. I encourage you to find more information out about this. Again, this is a link that you can go out to learn more about Creative Commons licenses if you have a moment. Okay, very quickly, we're going to talk about some of the major parts of contracts, and then we're going to jump into actually looking at some contracts. So one of the things that you are always going to see on a contract is a grant of rights. The grant of rights is going to be where they talk about, the publisher is going to talk about whether they're requiring you to transfer your copyright to them, usually in whole, if it's a traditional sort of publication or traditional publishing form, or where they're going to be talking about what permissions you're giving. And that's going to sort of dictate what kind of license they're going to put on the work, okay? Sort of CC license. The representations and warranties part of the contract, usually this part covers things like, and representations and warranties don't mean anything more than promises. I promise that my work is original. I promise that I don't have any libelous or defamatory information in my work, okay? Because the publisher doesn't want to get sued. There's no violations of privacy in my work, and that I have obtained permissions for anything that I'm using in my book that is copyrighted to someone else. So, for example, if I were using a picture that someone else had copyrighted, I would have to have gotten permission to use that picture, that image, okay? So I'm just making those promises to the publisher. That's all really representation and warranties means. You might see a section about retained rights, and that is going to talk about permissions that you might keep even if you're transferring copyright. So this is where the contract might stipulate that if you want to reuse an image that you've created and published in your book, that they may just give you permission right there. They may just say, oh yeah, you can do that. You can reuse images. That's not a problem. You don't have to ask permission of us, okay? There are going to be what I consider to be sections really relating more to the logistics of the book publishing process, okay? So these are things like when you are expected to deliver your manuscript to them, how long the manuscript should be, and then all of the description of the editorial workflow and how you are promising that you're going to turn around the page proofs in a certain amount of time, and you're not going to make extraordinary changes once things have been typeset, and all of those kinds of things. And then usually there is a section about royalty terms, and this is concerning how much you will be paid when your book is sold by the publisher. Okay? And we're going to talk about this a little bit more, but this is one thing I felt that I really wanted to highlight during the presentation portion of today's little get-together, and that is rights reversion. So it is becoming much more common, and many university presses are actually talking with authors about this up front. It is becoming much more common for rights reversion to be written into book contracts. And rights reversion means that even if you're publishing in a traditional manner, you're not publishing open access, that you can talk to your publisher about when your book goes out of print, can I have my property back? Will you give me my copyright back and allow me to do whatever I want to do with that book? This is really important because when you think about, remember I told you earlier we were going to get back to the length of copyright? So when you transfer copyright to your publisher, even though they now own the copyright, it still is the same length of time. So it still lasts for that incredibly long period of time. And if you think about academic books in particular, we're not talking about Harry Potter here, right? We're not talking about books that make millions upon millions of dollars. We're talking about academic books that usually have a very, very small market. In those cases, the book usually is going to go out of print in about 5 years, if not sooner, okay? And that means your property is going to sit there unused for the rest of the term of copyright. And people, in order to access your work, are still going to have to hopefully find, if they need a copy of it, maybe they can find a secondhand copy at Powell's, you know, or somewhere else online, on Amazon or something like that, or at a library. But otherwise, nobody, say 30 years from now, is going to be able to buy a copy of that book. So if you think about talking to your publisher about rights reversion up front, could I have my rights back when it goes out of print? Could I have my rights back after 10 years? Could I have my rights back at some point in the future? And you can negotiate what that point might be, okay? And university presses are starting to realize that this is actually a really good thing, because it often really raises their visibility when rights go back to an author and that author then releases the book with an open access license and makes it openly available. Sometimes it really helps to bring some visibility to the press. And in fact, this year, just about a month ago, Johns Hopkins University Press, I think it was JHU, right? That just released 100 books, open access, that were out of print. You didn't see that news? Okay. I'm pretty sure it was Johns Hopkins. And they worked with Project Muse to make 100 out-of-print books openly available for free, because they were just sitting in their back catalog and they were doing nothing with them. So the press actually took the initiative in this case and went to the authors of these books and said, this is what we want to do. Is it okay with you? And you know, the authors said yes. So there are 100 books out there freely and openly available through Project Muse that were not available for free before they were available. Okay, so let's take a look at some of the handouts that I have given you. And think about some of these questions. So I've got, as I said, I've got this handout that has the title of today's presentation on the front. And it's got a lot of the information that I talked about in it. So the information about copyright, things you want to think about when you're looking at your contract. Do you want to make use of this book in your own teaching? Do you plan to give lectures using parts of the book, such as figures or graphs? Are you including your own photographs or other images? Do you think your book would make a good movie or documentary? Do you want to control the presentation of your scholarship and not have it abridged? So if you say yes to any of those questions, I strongly encourage you to consider what rights you might want to keep and what you want to assign to the publisher. So the term of copyright is very long, and you don't want to have to deal with always going back to the publisher and asking permission for these things for the rest of your life, because that's what it is, okay? So one of the clauses that I didn't talk about that you'll often see in a book contract is what is commonly referred to as a slave clause, and that is the right of first refusal on your next manuscript. So unless you are absolutely positively sure that you want to publish with this same publisher again, you might want to strike that clause, okay? Because basically what that clause says is that the publisher that you're working with now has the right of first refusal to your next manuscript. Before we go further in talking about negotiating, I think it's really important to point out that many times, especially first-time authors, are intimidated by talking to their publisher and asking questions and possibly negotiating a contract. And what I would really want you to strongly think about is the fact that you have a lot of power in this relationship, because the publisher has already invested a lot of time in your manuscript. And by the time you get to the contract signing phase or negotiation phase, they're not going to probably, just because you ask some questions or ask for some things to be changed in the contract, I have never, ever heard of a publisher getting mad and walking away from a publication deal because, you know, an author asked questions. So, and authors are becoming much, much more aware of the fact that they can ask these questions, and publishers really are starting to expect it. Have you ever heard of a publisher walking away? No. Yeah. So, and it doesn't have to be, you know, confrontational. Oftentimes you can form your negotiations in the form of a question, just like answering Jeopardy quiz things, right? And that advice is farther down on this handout. You may want to consider strongly whether you'd want to have a non-compete clause. This is on page 2. And the next point is the reversion of copyright to author, which I already sort of strongly talked about. I think this is probably my biggest takeaway that I would like you to have from this workshop today, and that is to really think carefully about whether you want to ask for rights reversion. There's sometimes in contracts you'll see language around new editions, and because you have transferred the copyright of your work to someone else, to that publisher, if you're publishing in the traditional model, they can publish a new edition of your book. They can hire someone else to work on it and publish a new edition without even talking to you, and that has happened. Now, most publishers are not going to do that. Most publishers are going to have the courtesy to talk to you, but legally they don't have to because you don't own that property anymore. So you may want to think about that and how you might want to talk to the publisher about that scenario. Make sure that you can meet the timelines and deadlines that the contract lays out, because this is a contract. And while it doesn't have that timelines and deadlines don't have anything to do with copyright law, they do have to do with contract law, however. So if you sign a contract saying you're going to deliver a manuscript by X date, make sure that you can do that. Be aware that you're probably going to be asked to pay for any permissions that you have to get for materials that you don't own copyright to, say like an image. And you will have to either do the index or pay someone to do the indexing. Yes?
So if I have a young adult book, I have a vision that I would also like to do it for younger readers as an illustrated version.
Uh-huh, like a picture book.
Maybe
Mm-hmm.
even a graphic novel. If I signed a contract for the YA, do I then have to get permission to use that material, even if it's not the same text?
Even if it's not exactly the same,
Yeah.
I mean, it's probably going to depend on how much you change it, but if it could be considered a derivative work under copyright law, then yes, you would have to get permission. And I would have that written into the contract up front.
Right, so I want permission to be able to
Adapt.
Okay.
Yes.
That's it.
Right? Yeah, definitely. That is a really good example of a derivative work. So copyright law, that bundle of rights gives you the rights. One of those things is to make derivatives, right? And when you give all your bundle away, you don't have that part of your copyright anymore. So it's definitely, and another big way in which derivatives comes up is translations. So a translation of a book that you've written is a derivative work. If you want to be able to have some control over a translation of your book, if you think it might be translated, you would probably want to talk to the publisher about that and have that written into the contract, okay? If you think that people might want to read it in a different language.